days ago, the US Supreme Court did something that hasn't happened in modern American history. It struck down a sitting president's tariff program. This is the largest US trade tax increase in 30 years, and it's gone, just literally speaking, overnight. But within hours, President Trump announced a new one.
Exactly, which tells you everything you need to know about where we are.
It really does, because the question I've been getting from forwarders since Thursday morning, and it's the right question, is if the legal basis changed, but there's still a tariff, what's actually changed for me? And that's what we're digging in today. I'm Pauline van Ostaeyen, the co-founder of Duckflow, and joining me as always is Michiel Gabriëls. Welcome to the Duckflow Dispatch.
Good to be here. And I'll say, this one's been sitting in my research queue since last week, and timing could not be better. Or worse, depending on your lane mix.
Exactly. Let's get into it.
Let's start with what the court actually ruled. And I want to make this accessible without over-legalizing it, because the core of the case is actually pretty simple. There's a 1977 law called IEEPA, and it's the International Emergency Economic Power Act. It was built to let presidents freeze assets and impose sanctions during national emergencies. Iran, Russia, North Korea, that's the territory it was designed for. What it had never been used for, in its nearly 50-year history, was tariffs.
Not once.
Not once. And yet, that's exactly what the administration did on April 2nd last year. Liberation Day, as they called it. They declared a national emergency over the US trade deficit and used IEEPA to impose a 10% baseline tariff on virtually everything coming into America. Plus, higher country-specific rates. China at 145% and the EU at 20%.
And that triggered one of the most volatile years in container shipping history. We'll get into the numbers in a moment, but just walk me through the challenge, Michiel, because the way it started really matters.
Exactly. It didn't start with governments. It started with 5 small American businesses. A family wine importer, a toy maker, a cycling company, a pipe manufacturer, and a fishing equipment retailer. They argued through a group called the Liberty Justice Center that the IEEPA simply does not say anything about tariffs. A trade court agreed, a federal appeals court agreed 8-4, and then last Thursday, the Supreme Court agreed 6-3.
Okay, and there's one line from the Roberts ruling that we keep coming back to, and it's worth quoting directly.
Exactly. Based on 2 words separated by 16 others in IEEPA, regulate and importation. The president asserts the independent power to impose tariffs on imports from any country, of any product, at any rate, for any amount of time. And then, those words cannot bear such weight.
That's a decisive statement.
It's a significant ruling. And the split matters. Gorsuch and Barrett, both Trump appointees, joined the majority. The 3 dissenters were Thomas, Alito, and Kavanaugh. This wasn't a close political call. It was a genuine legal conclusion that the administration had fundamentally overreached.
So what has now replaced the IEEPA tariffs?
Within hours, Trump announced a 15% global tariff under Section 122 of the Trade Act. And Section 122 is a very different instrument. 3 things matters. First, a hard 150-day expiration. That's approximately the 24th of July, 2026. Second, it caps at 15%. There's a statutory ceiling. And third, extending it past those 150 days requires congressional approval.
So where does that leave the effective tariff rate right now?
Yeah, so now it's down from roughly 27% at the peak last year to around 9 or 10% today.
That sounds like good news.
It does, but the pre-Trump effective average was about 2.4%. So we're still nearly 4 times higher than we were before any of this started. The chaos has eased, but the structural increase has not.
And there's also a second piece that I want to make sure we don't bury, which is the port fees on Chinese-built vessels.
Right, and it's crucial because the Supreme Court ruling had absolutely no effect on these. They operate under entirely separate legal authority, Section 301, targeting Chinese dominance in shipbuilding. They've been live since October 2025. And for a Chinese-built vessel operated by a non-Chinese company, for instance, MSC, Maersk, Hapag-Lloyd, all of whom have heavily Chinese-built fleets, we're now looking at around $180 extra per FEU on Asia-US. West Coast routes right now, according to Drewry's modeling, that escalates to $338 per FEU by 2028.
And what about for Chinese shipping lines and Chinese carriers directly?
Drewry projects $1,400 per FEU for COSCO-operated vessels by April 2028. That could exceed half the spot freight rate at current levels.
Right, that's not just a surcharge, that's a structural challenge.
Definitely. For COSCO on US trades, yes. And the fleet exposure is enormous across the whole industry. MSC has 92% of its order book from Chinese shipyards, Hapag-Lloyd 89%, Maersk 79%. These companies are actively rotating Chinese-built ships of US trades right now and replacing them with Korean and Japanese-built, which are commanding significant charter premiums as a result.
I see. And one more thing before we move on, which is the refund question. There's $160 billion sitting in the middle of this that we should name.
Yeah, the IEEPA tariffs ran for almost a year. April 2025 through last Thursday, that's approximately $160 billion taken from importers under what's now been ruled an unlawful program. The administration had signaled refunds following a final and unappealable decision. That language was in a January 2026 order, but Trump has already indicated he may litigate refunds for years. Nearly 2,000 importers have filed protective claims. Justice Kavanaugh, in dissent, predicted the process would be quite a mess.
Which may be the most accurate legal forecast of 2026.
Yeah, that is quite hard to argue with.
All right, so the legal picture, it's complicated and it's staying complicated. So let's talk about what a year of this has actually done to shipping, because the numbers from Northern European ports, at least, are striking.
That's true. Hamburg tells the sharpest story. Full year 2025 throughput was actually up 7.3%. But US-bound container traffic collapsed 25.6%. The port compensated almost entirely through Asian volumes. China up 6.5%, Malaysia up 84%, and India up 49%.
So the headline number looks fine until you look at where the freight is actually coming from.
Exactly. And that shift matters beyond the headline. If your model is built around transatlantic westbound freight, those volumes aren't coming back to 2024 levels under any plausible near-term scenario. Hamburg's 25.6% drop isn't an anomaly waiting to reverse. It's the new baseline.
And what about Antwerp-Bruges?
Interesting one. Antwerp-Bruges surpassed Rotterdam in Q1 of 2025 in container volume for the first time in its port's history.
That is remarkable.
Genuinely historic. And then Q2 throughput fell 2.4% year on year. Steel exports to the US dropped more than a third under Section 232 tariffs. The port CEO described it as Resilience in a particularly volatile climate, which is measured way of saying that the numbers are mixed.
And Rotterdam's had its own pressures stacking up.
Oh, Rotterdam had everything at once. The Gemini Corporation Alliance reshuffling, Red Sea diversion still routing through the Cape of Good Hope, and a terminal strike at Hutchinson Port Delta 2 in February 2026. Shanghai to Rotterdam, spot rates were around $1,613 per FEU by early October after 10 consecutive weeks of decline.
And where do the rates sit now broadly?
It's depressed. Drewry's World Container Index was around $1,919 per FEU in mid-February. The Shanghai Containerized Freight Index at around 1,251 points. A big part of that is overcapacity. Global container fleet capacity has grown 19% since Q3 2023, and the order books are enormous and scrapping is close to zero.
And that overcapacity story connects directly to something I want us to spend a moment on, because I think it's the most underappreciated consequence of the vessel fee story for European forwarders.
Exactly, the displacement effect.
Let's walk through it, because it's not immediately obvious why a port fee affecting US trades changes anything for someone working Asian import lanes into Europe, for example.
Right. So the major carriers are rotating Chinese-built tonnage of US trade to avoid the escalating fees, replacing those ships on American routes with Korean and Japanese-built vessels. But the Chinese-built ships don't disappear. They redeploy, predominantly onto Asia-Europe and intra-Asian routes. That's additional capacity on the lanes European forwarders depend on for Asian import freight. More capacity on those lanes means more rate pressure, which means tighter margins on the Asian import business that's actually growing.
So you're potentially squeezed from both sides, less westbound US freight and rate compression on the Asian lanes filling the gap.
Exactly. And carriers are absorbing enormous cost pressure themselves. Alphaliner estimates the annual financial impact of the vessel fees on top global carriers at around 3.2 billion dollars in 2026. Costco alone carries $1.5 billion of that. Zim, $510 million. Companies under that kind of pressure either pass it through as a surcharge or they absorb it and consolidate further. Neither option is comfortable for the forwarders.
Well, let's talk about what this meant for the forwarding industry directly, because there's a detail in Kuehne+Nagel's results that I think tells the whole story.
Yes, their Q3 2025 EBIT was down 34%. They launched a cost reduction targeting over 200 million
Swiss francs.
Exactly, thank you, Pauline, in savings, and cut somewhere between 1,000 and 1,500 jobs. DHL was downgraded by the Deutsche Bank, and DSV trimmed its outlook.
And buried in Kuehne+Nagel's results, almost a footnote, is that demand for customs clearance and consulting services has remained high due to the tariff situation and the increased complexity. And in the middle of a 34% EBIT collapse, one service line actually held up because the same complexity that crushed volumes actually created demand for people who could help navigate it.
Yeah, that's not a footnote. That's a signal.
It really is. And the framing I want to leave on this segment, because it captures where we genuinely are, comes from Drewry's Simon Heaney. He said, the outlook for container shipping is more uncertain now than it was at the onset of COVID. That's something worth sitting with.
Yeah, that's because COVID was existential. Ports closing, demand falling overnight, but it had a trajectory. You could model recovery curves. This is different. The legal basis for the entire US tariffs regime can shift in a single court ruling and be replaced with something equally temporary in hours. That's almost harder to plan around because it has no trajectory. just elections, courts, congressional calendars, and competing political incentives.
And the 150-day Section 122 clock is the crystallization of that. So any forwarder looking at contract renewals right now is looking at a regime with a known expiry date of approximately the 24th of July, and really no certainty of what comes after, which is exactly where we need to go, because it's uncertain. Yeah, that's not a strategy. Oh, all right. So now what? Let's talk about 3 very concrete moves, things you could actually act on this week.
Yep. First, we have the 150-day clock.
Yep, that is the most immediate one. So Section 122 expires around the 24th of July, and Congress has to actively approve an extension. And given the current political environment in Washington, that's not really easy to assume. So practically, any contract or quote you have on US-bound freight needs a tariff adjustment clause. Not eventually, but now. If you're in renewal conversations with clients or quoting on US lanes and there's no tariff contingency language in that agreement, you're really carrying a risk that you haven't priced in. CLECAT, which is the European Freight Association, they've already issued guidance to members on updating their contract language. If you haven't looked at that language, that guidance, it's time to do so now.
Yes, and it's not just the expiration to plan for, it's what comes after. The administration has already signaled new Section 301 investigations, Section 232, expansions potentially into copper, lumber, semiconductors. The regime after Section 122 is likely to be more targeted and more complex, not simpler.
Yeah, and that leads us directly to the second move you can do right now.
Yeah. Customs complexity as a service.
Exactly. So the regulatory landscape around US-bound freight right now is very genuinely complicated. Section 122 is the baseline. Section 301 with product-specific rates on Chinese goods comes on top of that. And then there's Section 232 for steel, aluminum, anti-transshipment rules, imposing a 40% tariff on goods with more than 30% content from higher tariffed countries. And the vessel port fees applying at the US port, regardless of what's in the container. So no shipper can actually navigate that alone. Most medium-sized importers don't have the in-house expertise to model their landed costs under 3 different tariff scenarios simultaneously.
No, exactly. And Kuehne+Nagel's numbers show that clearly. Even as overall volumes fell, their customs and consulting revenues held. That's not a coincidence. That's a service people genuinely need right now.
Yeah, so if you're a mid-sized forwarder without a customs advisory offering today, the question isn't whether to build one, it's how fast you can build one. That might mean bringing in an expert or partnering with a customs broker or getting one person in your team really properly credentialed and positioned as your tariff intelligence resource for clients. Ja, oké. Even, let's go. Ik ga mijn laatste zin opnieuw doen. Hè? Ja. That might mean bringing in an expert, partnering with a customs broker, or getting one person in your team properly credentialed and positioned as your tariff intelligence resource for clients. So the forwarder who calls a client next week and says, here's what the Section 122 expiry means for your specific product category and all 3 scenarios on how to structure your sourcing, that forwarder is not just solving a problem, but they're actually building the relationship that doesn't go away when the regime might change again.
Exactly. And then we still have our third move. Lane diversification.
Mm-hmm. Yeah, this one is more strategic than operational, but I'd argue it's maybe the most important. So Hamburg's US-bound traffic, for example, fell 25.6% last year. Those numbers aren't a temporary dip. It's a structural demand for westbound transatlantic freight that has shifted. So some cargo has moved to nearshoring closer to the US, some has been canceled, and some has been permanently redirected. So the cargo that left those lanes mostly has stayed gone.
Exactly, but it didn't disappear. Asia-Europe is growing, Southeast Asian origins are growing, Vietnam, Indonesia, Thailand, India are all showing significant increases on European import lanes. Chinese exporters are diversifying away from America after last year's tariff shock, which means more of their goods are coming to Europe, Africa, Latin America.
Yeah, the freight is moving. And the question is whether you're positioned on the lanes where it's actually going. So it's not about abandoning US business, it's about not being overexposed to a single corridor that's in structural decline. So build the relationships with Southeast Asian freight agents now. Develop the lane expertise before you need it urgently.
Yeah, and the operational complexity of managing a more diverse lane portfolio, more origin points, more regulatory environments, more handover moments means that the forwarders who have genuine visibility across all of those shipments are going to have a real advantage over those still managing by email.
All right, let's close this out. The Supreme Court ruling is historically significant. The first time a judiciary has struck down a sitting president's tariff program. But for a freight forwarder in Antwerp or Rotterdam or Hamburg, the ruling changed the legal foundation without actually changing the economic reality. So the effective tariff rate has come down from its peak, but it's still 4 times what it was 2 years ago. The vessel port fees are still escalating through 2028, and in approximately 150 days, we'll do this again. The forwarders who really come out of this period in better shape won't be the ones who waited for clarity. They'll be the ones who made uncertainty the thing that they offer to solve for their clients.
That's true. So we'll be watching the July 24th date. We'll be back on this before then.
Thanks for listening to the Dogflow Dispatch. If this was useful, share it with someone navigating this and find us at dogflow.com.
See you next week.